When and where is it a good time to have a privileged conversation with your attorney? My name is Carl Burkhead. I'm an attorney with Worth Law Office in Tulsa, Oklahoma. I want to help you make law easy by talking a little bit about when and where privilege applies and when and where it's really best to just maybe not have that conversation. Okay, so attorney-client privilege, I'll just give you a brief overview. It applies when only you and your attorney are involved in the conversation. So if you're emailing your attorney and nobody else is on the email chain, or you're on the phone call directly with your attorney's office, or you're meeting with your attorney one-on-one, if you're trying to talk with your attorney about sensitive stuff in public, it gets dicey and you've got to be careful. There's plenty of times where, if I'm in court with one of my clients, we've got a notepad, we'll write notes back and forth during the middle of the hearing just to make sure that we preserve confidentiality and still can exchange information back and forth. But sometimes people kind of forget that privilege doesn't apply if other people hear it. So, I mean, if it's something where you say I'm your lawyer and we have a conversation and you go home and you tell your best friend everything we talked about, word for word, or you show your family just our email chain. That breaks confidentiality because then there's other people who are not me and not the client who know about what was said and can then be called to testify about it. It seems kind of silly, but it can get pretty important. The other day, I was in court on a criminal docket, and as I'm walking out of one courtroom, I see a lawyer and client walking out of another courtroom, also a criminal docket over there. And this client is very loudly, for his attorney and for all of creation to hear, going, I don't know why they're telling me I can't put hands on people. Watch me put hands on whoever I want to put hands on. They don't know who they're talking about. I will put hands on my best friend, my sister, my auntie, my cousin. I don't care. I'm like, huh? Everyone could hear it. Everyone could hear it. I can only assume that this is some sort of protective order violation case, or assault and battery, or maybe even worse than that. I don't know. All I know is no matter how you're feeling, if you're feeling some type of way about how your case is going, or what you feel about how the judge is telling you can or cannot act, yeah, you can vent to your lawyer about it and y'all can talk about it. But man, don't do it in the courthouse when there's everyone there that can hear it. All it would have taken was someone from the DA's office who was familiar with that case, who knew that client, who knew the charges, to have heard that and go back and talk to the state about it. Or, if the prosecuting attorney heard that themselves, it's not going to do you any favors. Anyone that heard that exchange can now be called as a witness about it, and that can be used against them at trial. Maybe the prosecutor hears it and they decide they're not going to go with the plea deal that they negotiated with that person's attorney, or maybe they decide that they're going to pursue a heavier sentence, or maybe they had filed something as a lighter charge and they decide based on that attitude they're going to try to amend the charges. It's not good, and it's very, very easy for just the wrong person to hear what you're saying, and then your privilege with your attorney goes out the window and it can be used against you. If you have questions about this, or if you're wondering, maybe when and how to discuss these things with your attorney, or maybe you're needing a lawyer and you're wanting to have a confidential conversation about it, please give us a call. My name is Carl Burkhead. I'm with Worth Law Office, and I want to help you to make law easy. Thank you.